not Murdaugh. Yeah, State v. Murdaugh in the Satterfield case. Unless you want to voluntarily join in.
Your Honor, I do not voluntarily join in anything.
All right, well.
Your Honor, I apologize, Mr. Moore. Just have to say it.
All right, well, I thank you all very much.
Thank you, Your Honor. Thank you.
We'll take 2 or 3 minutes and then move back to the Lafitte matter. Veterans Day is on the Friday the 10th, is that it? Well, the deadline will be Thursday the 9th. How about that?
Responses in 5 days.
And responses in 5 days will determine when and if a hearing is needed prior to the 27th. If you'll put all of that in order and circulate it to council for any comment, and I'll sign a written order addressing all of what we've just discussed.
More prepared, Your Honor.
All right, anything else we need to talk about in this case?
Your Honor, I hate to rise.
I said in this case. No, you're not in this case, are you?
Yes, Your Honor.
Well, we're coming to you next.
I know, I'm just charged with him in the other cases.
You're charged with what?
My client is charged jointly with Mr. Murdaugh and 3 other cases. They're not been scheduled.
Well, he's indicated he's calling the State v. Murdaugh, State v. not Murdaugh. Yeah, State v. Murdaugh in the Satterfield case. Unless you want to voluntarily join in.
Your Honor, I do not voluntarily join in anything.
All right, well.
Your Honor, I apologize, Mr. Moore. Just have to say it.
All right, well, I thank you all very much.
Thank you, Your Honor. Thank you.
We'll take 2 or 3 minutes and then move back to the Lafitte matter. Veterans Day is on the Friday the 10th, is that it? Well, the deadline will be Thursday the 9th. How about that?
And then responses in 5 days.
And responses in 5 days will determine when and if a hearing is needed prior to the 27th. If you'll put all of that in order and circulate it to council for any comment, and I'll sign a written order addressing all of what we've just discussed.
More prepared, Your Honor.
All right, anything else we need to talk about in this case?
Your Honor, hate to rise.
I said in this case. No, you're not in this case, are you?
Yes, Your Honor.
Well, we're coming to you next.
I know, I'm just charged with him in the other cases.
You're charged with what?
My client is charged jointly with Mr. Murdaugh on 3 other cases that have not been scheduled.
Well, he's indicated he's calling the State v. Murdaugh, State v. not Murdaugh, yeah, State v. Murdaugh in the Satterfield case. Unless you want to voluntarily join in.
Your Honor, I do not voluntarily join in anything.
All right, well.
Your Honor, I apologize, Mr. Moore. Just have to say it.
All right, well, I thank you all very much.
Thank you, Your Honor. Thank you,
Thank you. You may be seated.
Your Honor, we're back on the record, State versus Russell, Lucius Lafitte. Again, he's here represented by counsel Murdaugh, who was here. Again, back here to discuss status in a trial date. And as always, Your Honor, the State is prepared and will be prepared to go forward in any date that the court sets. I know the defense has some issues with that, so I will
Can you remind me about Mr. Lafitte's various indictments, the venue, and all that?
Yes, sir. For Mr. Lafitte, we have 2022 GS 4701 and 2022 GS 4702. Those are both venues in Hampton County, and those deal with the victims there are Ms. Thomas and Steve Pinckney. Then in Allendale County, we have 22 GS 4703. Again, venue in Allendale County, and the underlying victim there is Mr. Badger. 2 in Hampton, 1 in Allendale, Your Honor.
All right, Mr. Moore?
Yes, sir, Your Honor. He's charged with Mr. Murdaugh on all 3 of those cases. They're co-defendants in all 3 of those cases. I would ask, Your Honor, because as I understand it, the State wanted to go first with the Satterfield matter. That case has been set. I would ask, Your Honor, to set a trial date for one of these cases in the fall of next year. As I mentioned, and I know Your Honor doesn't want to hear about the federal case, but it's inextricably intertwined here. And one of the things that I have to do to represent this thing is that I've got a briefing schedule, and we've got to deliver a briefing to the Fourth Circuit Court of Appeals this fall. We have to do that. I don't have any choice in that matter.
To deliver briefs where?
To the Fourth Circuit Court of Appeals.
Fourth Circuit Court of Appeals.
Yes,
concerning what?
Well, so he is appealing his federal conviction. And so the Fourth Circuit set a briefing schedule, and they originally set a schedule for September the 28th. As I mentioned earlier, the United States Attorney's Office then filed a cross appeal. The Fourth Circuit consolidated those matters. They abrogated the briefing schedule, but now they will set a new briefing schedule. I expect to get a briefing schedule in the next week or two, and I expect, because of how quickly the other briefing schedule was set, that we'll get a briefing schedule where that briefing we do at the end of October, or maybe, if I'm lucky, mid-November. I've spent way more time focusing on the they have a case now. We have not been through that discovery. I'm going to need the opportunity to do that with Mr. Lafite. That may be very complicated because, again, I don't know today, perhaps we'll know by next week, whether he's going to get an appeal bond or not. If he does not get an appeal bond, he's going to be in Coleman, Florida. That's where he's been designated to serve his sentence. And I need some time and some access to him to be able to prepare for his defense in this trial. And so I would again, Mr. Rutherford, as legislative immunity, as Your Honor knows, I understand that the state may want to talk about trying the case in the spring, but I would ask Your Honor to set, and perhaps, I don't know if the state intends to try all three of these cases or not. I don't know what the current is. I think Mr. Waters can speak to that. I'm not the president for it. But I would ask Your Honor to set those cases for the fall. What I would ask. Thank you. I can tell you, Your Honor, that I will have motions filed in those cases. But I'm just saying, I don't see physically how I can try this case with this client this fall, given not only that appeal, but this discovery. I would be ineffective. I would be. And I don't want to be ineffective in this matter.
All right. Mr. Waters.
Your Honor, as a true discovery, first I'll point out, and I'm not unsympathetic to the fact that Mr. Moore and then much later Mr. Rutherford have now joined the defense team, but that's not the state's fault that Mr. Lafite changed lawyers. The discovery of this matter has been out for a long time, and again, it is extensive, but as he said, much of the discovery is very similar and generated by the state grand jury as to things that they've been reviewing in the other matter. The discovery we provided is base label, a very detailed Excel sheet that goes through all of that. But ultimately, Your Honor, there is a distinction between what has been previously tried in the federal court, which again, it's not what's going on here. In that particular case, what was litigated, what was indicted by the federal government after the state grand jury had indicted the case was Mr. Lafite's providing of the $750,000 undocumented loan to Murdaugh, as well as providing the $680,000 to the law firm when all of this started to come to light. And they did present some of the evidence of the underlying victims as the sort of the background to leading up to what they charged here. But what's charged in the state grand jury is the underlying offenses of these victims. The victims being Ms. Thomas, Mr. Hakeem Pinckney, Mr. Badger, and that's a distinct matter, and that actually goes back for almost a decade or more. So we believe, Your Honor, that again the state is prepared and happy to come try this case whenever Your Honor finds a date, and we're happy to do it in the fall as well. If that's not going to work, and Mr. Rutherford wants to look at something in the spring, I guess we could talk about that, but I think, the fall is really our sweet spot for trying to get some of these things moving. What I don't want to have happen is just to defer anything until all the way to the fall of 24. Again, these cases go to the heart of the South Carolina state judicial system. It's important that these allegations be litigated in court, and just deferring everything into the fall of 24 and going through the same process again in the hopes that something can get scheduled prior to the safe zone being reached again, I just don't think is appropriate for justice in this particular case. So again, the state is here. The state, if the date gets set, the state will be prepared and ready to go try the case.
Yes, sir.
One brief point. So I don't necessarily, I didn't try the federal case. Okay, I came in after the fact. But I have reviewed that transcript, and I reviewed the indictment, and I don't necessarily agree with Mr. Waters. The federal government didn't just charge those two bank fraud counts. They charged an underlying mail-in wire fraud and bank fraud conspiracy that included the conduct reflective of Mr. Lafite and Mr. Murdaugh's dealings with the alleged victims who were in this case. So there were counts that dealt with those victims. I tell Your Honor that to tell you that because I think Your Honor should know that. And those folks testified. The one thing that is, and I'll tell you what I have not done yet, I have not tried to relate the discovery that we've gotten in this case with the discovery in the federal case. They're different. But in this case, there's the testimony of 30 separate grand jury witnesses before the state grand jury. I haven't read those transcripts, Your Honor.
You have not read those
I
transcripts?
have not read those transcripts as of yet.
When is the first time you appeared at a status conference in this case and requested more time?
I appeared at the status conference, I believe, back in April, Your Honor, and we've been dealing with the federal case ever since. And I understand that the federal case is different than the state case, but I was not aware until today that we might be talking about trying cases in fall. And that's on me, okay? And if I have to get ready, I have to get ready. But I have not read all 30 of those transcripts. I have not. I have looked at a couple, but I have not read all 30 of them. I have not.
Yes, sir.
Even back in April, we were saying that we were ready to try the case whenever a date could be set, and expressed then that we were looking at the fall. And I think that Mr. Rutherford had just joined the defense team the day before, and I remember the exchange very clearly. He said, well, I haven't even gotten the discovery yet. I was like, well, you just joined the case yesterday. So, I mean, again, the defense has had this discovery for a long time. This is September now. This is 5 months later. And again, I understand the difficulties the defense is facing, but this case has been indicted. The discovery's been to the defense team for an extended period. And if we don't get this done before the end of the year, then we're looking at the fall of 24. And I just believe that's too long to wait for the importance of the allegations here.
When is the other co-defendant's trial scheduled? Is that Roberts or?
That is December 18th.
Is it Roberts?
Yes, sir.
December 18th?
Yes, sir.
What was the length of the federal trial?
I believe it was 2.5 when you count actual days, Judge.
2.5 weeks.
2.5 weeks, Your Honor. When you count opening statements and jury deliberations, I believe it was 2.5 weeks.
All right. Mr. Rutherford? Yes, sir. Anything you want to add to the discussion?
Your Honor, this is, as has already been stated, a case that took 2.5 weeks to try in federal court. These are allegations that our client has already been convicted of. Judicial autonomy asserts that he has already been convicted. He is appealing that case. We are working on that appeal, trying to get that into the Fourth Circuit. The state has the ability to call any case they want to and keep their foot on the gas, and this is all that they get to focus on. Judges can't make them call other cases the way the judges have made me work on other cases. We tried a murder case 2 weeks ago in Spartanburg that was a 2017 case, I believe. Almost every case that I have scheduled between now and the end of the year is older than this one. And several of them that I have are also with the Attorney General's office. Whether they call them, schedule them or not is up to them, not up to me. What I foresee them doing is trying to assert that they're ready, willing, and able to go. Just want me to, which, Your Honor, for the record, I'd happily do if they waived their ability to call cases whenever they get ready. If they waived their ability to only work on one case solely. We don't have that ability. The case that Mr. Arpulian and Mr. Griffith spoke of earlier in federal court in December, I have a similarly situated co-defendant. Their client is actually a trial. Mine is not, but possibly scheduled for that same week because it's the same facts.
Not the week of November 27th.
Not the week of November 27th.
Okay.
And as they have already stated, that week is reserved for the case that they decide to call, which involves the Satterfields, not the case that is connected to our client. And so that's what they chose to do. They have not told us exactly which case they choose to proceed on. And during the break, he said, that's up to him as to which case he's going to proceed on and when. And it is, unless he's willing to waive that. Until that point, Your Honor, 41,000 documents. There's a transcript that goes for 2.5 weeks in federal court, all of which there is no way that any lawyer could be prepared on between now and the end of the year if they're going to do their client a service so that the state can have justice. Justice at what cost, I'm not really sure. I know that there are victims in other cases that are awaiting their date. I was in court yesterday on a 2016 case and had to answer to Judge Colville as to why the case was so old. Well, this is the reason why cases get old. Prosecutors get to decide when they call it. They get to decide when they get their foot on the gas and stay there and demand that a case that was indicted in April of 22 now must go to trial before the end of the year, pushing aside every other case that is much older for an individual that has already been convicted and sentenced and got his designation in federal court. There is absolutely no reason, Your Honor, we would assert, for this case to move forward, and if so, it would require for a December date that I not be present during JMSC for the entire month where we're screening, I believe, almost 100 candidates for judicial seats. There's no way to do that and prepare for this. My schedule, Mr. Moore's schedule, the attorneys that work for us, getting together with Mr. Lafitte, it would require what the state already has the ability to do, which is put everything to the side and work on what they want to. We don't have that ability. When they waive that and give that up, I will give up my immunity. They will not, I will not. And that is why I believe that a trial date placing us in the fall is reasonable. Fall of 24 is reasonable given the factual circumstances in this case.
And Your Honor, if I could just add one other comment. If Mr. Lafitte's federal appeal is unsuccessful and his conviction and sentence is upheld, then he may have decisions to make about these cases that might not require a trial. And so I tell Your Honor that because I don't think anyone wants to go through a trial and put taxpayers to that extent if necessary. And I tell Your Honor that because I think I'll.
All right, Mr. Waters.
Your Honor, as to Mr. Rutherford's comments, he knows full well, of course, that when he's talking about cases in a particular circuit of the solicitor's office, that I have no control over that. What I do have involvement in and control over is the state grand jury charges. And obviously, Your Honor has been assigned by the Chief Justice of the South Carolina Supreme Court to preside over these matters. And so that's what we're here to deal with today, not what's going on in a different circuit in some other case. Mr. Rutherford elected to get involved in this matter. I'm not unsensitive to scheduling issues, but the state is here to say that if Your Honor sets a trial date, we will be ready and willing to try that case. And again, the state grand jury, it's its own docket, it's its own method of going forward. What the state grand jury focuses on are cases like this that are can be complex white-collar cases and cases that have a lot of underlying importance to the system itself. And again, my charge and the charge that was given to me by the Attorney General is to prosecute state grand jury cases, and that's what we're here to do. That's completely separate from the dockets that Mr. Rutherford may be dealing with in a different circuit elsewhere in the county and state system. So we believe that we're here, and again, he's saying that I'm calling the cases. We're here to say, Your Honor, give us a date, and we will try one of these cases. We can do the two Hampton cases together. They are similarly, they were both part of the same action. The Allendale case is a different case. That would need to be somewhere else. So if there was a case to do, it would probably be Hampton. We could do the two indictments there. But we are willing to try a case if Your Honor finds a date that works.
And Your Honor, what I would say back to that briefly is, if he wants to consolidate the Hampton cases, he didn't indict them together, I guess he'd have to make a motion to consolidate them, and then we'd have to respond. And I'm not in a position to tell Your Honor exactly what my position would be today. But I'll do whatever Your Honor tells me to do.
Okay. Anything further?
No problem, State Your Honor.
At this point, I think we're done, Your Honor, but happy to answer any questions.
When do you expect to know whether Mr. Lafitte will have to report to the federal institution?
Well, as I think I told Your Honor the last time we were together, which was a couple of weeks ago in King Street, I expected to know today, and that's one of the reasons why we all talked about setting the status conference today. I expected to know today. Our briefing has been concluded in the Fourth Circuit for several weeks now. And the Fourth Circuit is aware of the fact that Mr. Lafitte has a report date of next Thursday, a week from today. I've talked to the United States Attorney's Office about asking Judge Gergel. Judge Gergel has deferred his report date once because of the pendency of the Fourth Circuit's decision. If we don't have a decision today, and I'm expecting that we're not, Judge, I just checked my email to see if I'd seen anything, and we don't have a decision. If we don't have a decision today, I'm going to ask Judge Gergel today or tomorrow to extend his report date one more time, and the government told me they'd tell me what their position was at the end of the day today. I had that discussion with them yesterday, not this morning, but yesterday. But as Your Honor understands, if he does get a report back and his appeal bond is denied and he is transferred to Coleman, that's going to make it way more difficult for us to get ready to try a case this fall. Way more difficult.
Way more difficult to try the case this fall.
Yes, sir. Yes, sir, because I won't have access to him. He asked for a designation. Judge Gergel asked the Bureau of Prisons to designate him to Jessup. They designated him to Coleman in Florida, which is about 5 hours away.
You have the ability to request where someone serves their time?
Judge Gergel has the authority to recommend to the Bureau of Prisons, not order, but recommend to the Bureau of Prisons that a person be incarcerated in a particular location. The Bureau of Prisons does not always, and regularly does not, accept those recommendations. That is, I don't have that authority, the judge has that.
Did he accept your recommendation?
Judge Gergel recommended that the Bureau of Prisons incarcerate him at FCI Jessup, and the Bureau of Prisons.
In what state is that in?
Jessup is in Georgia. It's less than an hour from his home. It's sort of right over the Georgia border. And the Bureau of Prisons' general rule is that they're going to try to place you no less than 500 miles from where you reside, and he is in Coleman.
All right, any other words of wisdom?
pretty good upstate.
Well, I think we'll defer any decision about a trial date today until we can review things, maybe in another month or 6 weeks or so, and see where it all stands.
Thank you, Your Honor. We very much appreciate that.
All right. All right.
And Your Honor, I assume that if he gets your report date and we know he's going to be transferred immediately, Your Honor would expect me to notify the court?
Yes, sir.
And
Very well.
thank you, Your Honor.
All right. Thank you all. We'll take 5 minutes and then proceed with Fleming. Yes, sir.
May it please Court, Your Honor, we're here on the State versus Corey Fleming. Mr. Fleming is present with his counsel, Debbie Barbier and Nathan Williams. As Your Honor is aware, back on August 23rd, 2023, Mr. Fleming pled guilty to all the state grand jury charges against him. Those are 23 separate charges. Just very quickly to detail those. The first one is 2021 GS 4730, which was indicted by the South Carolina State Grand Jury in March of 2022, and that alleges 18 counts against Mr. Fleming for victimization of Gloria Satterfield's estate and ultimately her sons as beneficiaries of that estate. And I would point out that we do have representatives of the Satterfield family here today, as well as their counsel, Eric Bland. I believe some of the victims want to address the court at the appropriate time. Your Honor, we also have State Grand Jury Indictment 2022 GS 47-2. That was indicted by the South Carolina State Grand Jury in April of 2022. And that alleges 5 counts against Mr. Fleming, and that is where the victim is Ms. Pamela Pinckney. And we have here Representative Ms. Pinckney, Justin Bamberg, who's here. Ms. Pinckney wanted to attend, was unable to make it, but Mr. Bamberg will be speaking on her behalf here today. Your Honor, I'd like to, I know we went through a very extensive factual basis and put in a number, over 20 exhibits at the plea. And as I described it at the plea, I think that the issue here is if we were in traffic court and the speed limit was 55, and Mr. Fleming wants to say, well, I admit I did 58, and the state, if I'm the trooper, I'm like, no, Your Honor, we clocked him doing 90, weaving in and out of traffic like a video game. And so what I'd like to do, Your Honor, with the court's indulgence, is just kind of detail some of the facts that show the true and real extent of the conduct here, because again, it does go to the heart of the state judicial system. Your Honor, these allegations here involve the use of state law licenses in state court actions before state judges with state court approved settlements. So ultimately, Mr. Fleming has admitted to a violation and abuse of the state judicial system. And because of that, Your Honor, I would submit to the court that the state judicial system must defend itself. It must provide its own accountability for those who would abuse it. And that is what the state, and I believe the victims, will be asking Your Honor to do here today. Mr. Fleming admits that he conspired with Alec Murdaugh to steal money in both the Pinckney matter and the Satterfield matter. He admits that, Your Honor. He admits to colluding with Mr. Murdaugh in the Pinckney matter when he was recruited by Mr. Murdaugh to represent Ms. Pinckney because she was a driver in the crash, but also a plaintiff, and so they needed another lawyer involved in the case. Mr. Murdaugh represented the other clients, including Hakeem Pinckney. And in the Satterfield matter, as Your Honor has heard, Mr. Murdaugh recruited, put these cases in Mr. Fleming's lap. In the Satterfield matter, where Mr. Fleming was going to represent the estate and represent the sons of Miss Gloria Satterfield, but Mr. Fleming was going to openly, behind the scenes, collude with the defendant in that action. Not the attorney, but the defendant himself. And what Mr. Fleming, I think, wants the court to believe is even though the state grand jury, he initially reported to everyone that he was a victim of Mr. Murdaugh just like everybody else. Just like Mr. Murdaugh's law partners and just like his clients, he was tricked and fooled by Mr. Murdaugh just like anyone else. But what happened was the state grand jury, which again is a partnership of the Attorney General and SLED, and the people sitting around me and the SLED agents over there, right out of the gate, when we first got involved in September of 2021, and one of the things that we uncovered was that Mr. Fleming had been stealing checks from his clients going all the way back to 2012. all the way back to 2012. So when Mr. Fleming tries to tell this court that, okay, I stole a little bit, but I really was hoodooed by Alec Murdaugh as to the big money, I'd ask the court to consider that and consider this entire chain of conduct and whether or not that makes common sense and whether or not that fits with the evidence. Your Honor, what we see at the beginning of this case, the Pinckney wreck occurred back in 2009, and it resulted in terrible injuries to members of that family, injuries that ultimately contributed to Hakeem's death, injuries that Miss Pamela Pinckney, is still dealing with to this day. And what the evidence revealed is that Mr. Fleming knew how to interact with his clients. Early on, he's interacting with Miss P. He's developing that personal relationship with Miss P that you expect a lawyer to do in a case like this. He knows how to do it. But then what we see is at the same time where he's telling Miss P he's taking care of her, he's spending time with her, he's going to her hospital bed. It doesn't take him long to steal a couple of checks so that he and Alec Murdaugh can fly in a private plane and go to the College World Series. And he bills that. No one else did this. This is in his records from his law firm. He bills that to Crosswind as if it is a medical expense. And it was a private plane ride to go party with Miss P's money. And so when Mr. Fleming tries to tell you that he didn't really know what was going on throughout this entire decade-long scheme of conduct, I would ask Your Honor to take that into consideration when you look at what he really did and how long it's been going on. He dispersed a large sum of money to Miss Pinckney the right way. And there is no better feeling, I am told, for a plaintiff's lawyer or their staff that when they get to call in that person who's been hurt, who's suffered, and say, I know you've been hurt, I know you've been suffered, but I've got a check of life-changing money for you. Here it is here today. And in fact, that's how usually the scheme works, because those clients, those victims are so distracted by the big check in front of them that they're not paying attention to the sleight of hand behind them. And that's what Mr. Fleming did with his law license. Mr. Fleming stole those Crosswind checks in 2012. And one of the facts I have to reiterate for Your Honor is we mentioned another civil action in which Mr. Fleming was not actually the defendant, but he pretty much was the defendant because it was a close family member who was the defendant. And what the investigation revealed was that Mr. Fleming, as essentially the defendant, was doing the legal work in the case, and they were essentially using Alec Murdaugh's name as the plaintiff's lawyer. To the point where there is an email where Mr. Fleming sends to Alec Murdaugh's staffer the petition and the order with the settlement in there and says, hey, I need you to send it to the defense lawyer so it doesn't look like it came from me. And this man wants to try to convince you that he didn't really know what was up in his dealings with Alec Murdaugh. Ultimately, in that case, Your Honor, the order that was submitted, the settlement, reflects $48,000 in legal fees that were supposed to go on the paper to Alec Murdaugh. But instead, they ended up in the pocket of essentially the defendant and his family. And that's ultimately how the state grand jury figured it out, because we saw this $48,000 reference, but no $48,000 check coming into the PMPED law firm. But does it sound familiar, Your Honor? Again, I would ask you to consider that it was essentially Satterfield in reverse. Except this time, Mr. Fleming was the beneficiary as essentially the defendant of receiving monies that were supposedly going to the plaintiff and the plaintiff's counsel. Your Honor, that was going on 2012 through 2014. around the time that Mr. Fleming first stole from Miss Pinckney. And years go by to all the way to 2017. And Mr. Fleming still has money belonging to Miss Pinckney in his account. Money that he had retained supposedly for satisfaction of liens. But what we found, what we uncovered, was that was a perfect delta of money. Because once you settled those liens, or you just don't even settle them at all, that's money then that you can steal or steal from. And in 2017, Mr. Murdaugh cuts a check for $4,560 and delivers it to Alec Murdaugh, or causes it to be delivered for fake expenses of Miss P's money. Again, when you consider what he's trying to convince you, think about the entire course of conduct here and how these two men operated together. But more importantly, he also cuts a check for $89,000, over $89,000 of Miss P's money, and cuts it to PMP, and Alec Murdaugh promptly converts it to Forge. This is a man, again, who knew how to interact with Miss P, who had interacted with Miss P, who had sat by her bedside as she suffered from the injuries of that wreck. Does he call up Miss P in 2017 and say, "Great news, I got $89,000 more of your money"? Does he call up that client that he had that personal interaction with? No. He just gives it to PMP&D, gives it to Alec. Makes no effort to contact him. Again, when we look at this entirety of these events, and Mr. Fleming tries to tell you, okay, I got caught red-handed stealing a little bit, but I didn't know about all this other stuff. It doesn't fit with the evidence. It doesn't fit with common sense. But if we had any question, and we're going to get to the 3 checks in the Satterfield matter. There were 3 checks. There were one check for over $400,000 that Mr. Fleming made out from his trust account to just the single word Forge, which in and itself is ridiculous. Just the word Forge. A second check for over $2.9 million. This is money that's supposed to go to this family right here, Your Honor. Made out to the word Forge. And a third check for $118,000 made out to the word Forge. All of that money was supposed to go to this family, and it doesn't. Mr. Fleming, I believe, wants to convince Your Honor that when he cut those checks representing the proceeds that were supposed to go to this family and caused those to be delivered to Alec Murdaugh, made out to Forge, that he didn't know that Alec might take any of that money. That he thought every penny of that money was going to go to those boys. And it doesn't make sense. It doesn't make sense with the history here, and it doesn't make sense with the specific evidence in this case. And let's talk about the first thing that we have. Aside from just, it doesn't make common sense. It doesn't make common sense to make out a check just to the word Forge. It doesn't make sense because Forge doesn't take money in the traditional sense. It doesn't make sense because his own staff testified that Mr. Fleming did everything differently in this case. It doesn't make sense because Mr. Fleming, unlike we know how he does to do with Mr. P, never made an effort to talk to the Satterfield family. Never made an effort to find out if they got their money. Never contacted them. Never called them up and said, "Great news." Never told the PR that they pretty much brought in as a patsy to do that either. Never told him what to do. And I'll talk a little bit more about that in a second, Your Honor. In December of 27, though, if we had any illusion that Mr. Fleming, when he cut those checks to Forge out of his trust account, when he received the settlement money in his trust account, that that's not how you do a structure, we have that email that I detailed for Your Honor, where Michael Gunn at the legitimate Forge explained to Mr. Fleming and his staffer, you received the money, we can't set up a traditional structure.
What year is that again?
That was in December 20th, 2017 was that email, and that was State's Plea Exhibit number 5, Your Honor. And I have another copy of the plea exhibits, if Your Honor. I don't know if Your Honor has
Yes,
them.
sir, if you would.
I'll pass those up. That was December 2017. Just a few months later, in February of 2018, Gloria Satterfield, a longtime housekeeper for the Murdaughs, fell at Moselle and suffered injuries from which she ultimately succumbed on February 26, 2018. And Your Honors heard evidence that not long after that, Alec Murdaugh told the Satterfield family that he was going to take care of them. He was going to make sure that they got taken care of for their mother's death, for her long service to that family. And who did he bring in? His longtime co-conspirator, Corey Fleming. But Corey Fleming only met with them once or twice, if that. Met with them a couple times. He never had them sign a fee agreement, which is common practice, as Your Honor knows, required practice. He never updated the Satterfields on the status of the case. He never advised them about the recoveries. He never advised them of the settlement offers. He never advised them that money was being directed to Forge. He never, of course, told them that he and Mr. Murdaugh, as I'll detail, were dipping into their money for their own personal gain and expenses. And what's most important, Your Honor, is Mr. Fleming never told this family, never told Chad Westendorf, the PR that they put in as a patsy, what he's going to try to claim to Your Honor now, that he generously cut his fee in half and had no idea that Alec was going to take any of the other half of that fee. That's what he's trying to claim now. Cut his fee in half. And never once tells the PR that. Never once tells them that. You know what kind of lawyer I am? I'm going to cut my fee in half. $600,000 is enough for me. And why doesn't he tell them that? Because he's got an arrangement with Alec Murdaugh, and all the evidence in this case reflects it. It works out to be just like a fee split you see over and over again. And the reality is, the reason is because they co-litigated the case. Alec Murdaugh functioned as co-counsel with Corey Fleming, co-plaintiff's counsel, in a case where Alec was the defendant. It was a shakedown. Plain and simple. These boys, this family, deserve compensation. But they were nothing but a vehicle for Mr. Fleming and Mr. Murdaugh to steal money. Again, looking at common sense and what the evidence reflects. But in November of 2018, there's two policies, one for $500K, Lloyd's of London, and they pay on the policy. Well, guess what? At that point in time, Tony Satterfield is the PR of the estate. That's Mr. Fleming's client. Does Mr. Fleming call up Mr. Satterfield and say, Tony, great news, they tendered the policy limits. First check's in, $500K, $500,000. No, he does not do that at all. In fact, he, and we have the email, instructs his staff, hold this check until we can get the PR changed. Hold this until we can get the PR changed. Why in the world did he do that if he thought that that money was legitimately going to go to those boys? It's not. It was meant to put in the patsy so they could cover up what they were about to do. And the evidence is clear, Your Honor. That's State's plea exhibit number 6. In fact, they get the check. Lloyd's of London cuts that check on December 4th, and they make it out to Chad Westendorf. He hasn't even been designated as the PR yet. They haven't even changed it yet. They already get the check made out to Chad Westendorf. And Westendorf was clear, and the evidence is clear, that he was not instructed what to do. In fact, he was always told by Mr. Fleming, I got it. I'll handle it. Do I need to do anything? Do I need to open a bank account? No, I got it. I'll handle the disbursements. That's not Alec, that's Mr. Fleming saying that, according to the evidence gathered in this case. In December of 2018, Mr. Satterfield is convinced by Alec to sign over being PR of the estate so that this scheme can take effect. And an order is filed that retroactively says the date was back in March of 2018, which is a fabrication.
What date was that again?
December 18, 2018 is when the PR change is issued. That's plea exhibit number 7. And the date in plea exhibit 7, if you look at that document, says that it was effective from March 28, 2018. So again, plea exhibit 7, Your Honor. Complete fabrication. Chad Westendorf hadn't been contacted back in March. Tony was the PR. This is all after the fact to hide what they're about to do. And so when he says he thought that check that he cut to Forge, which he cut shortly after this, for $403,000 was actually going to go to an account for those boys, aside from the fact that that's not how it works, and it makes no sense, and it's made out to a single word, Forge. It's all an after-the-fact reconstruction to put in their patsy so they don't know that they've gotten a recovery. And Mr. Fleming is at the center of that. Aside from the fact that even if he tries to claim that when he handed those checks to his co-conspirator abusing the judicial system, if I didn't know what my fellow thief was going to do with it, that's not even good enough under the law anyway. When you're conspiring with somebody, you're responsible for the natural and probable consequences of that act regardless. But even that being the case, he knew, and the evidence is clear. I want to be clear. The state has never contended that Mr. Fleming thought that Alec was going to steal every single dime. Because that's not usually how the scheme works, right? As I just stated, you're usually handing some big check, life-changing money to people who've never had that kind of money before, and they're so distracted by that they don't realize you're stealing right from behind them. But for Mr. Fleming to claim that when he delivered those forged checks representing the vast bulk of all this money, that he thought that every dime was going to go to those boys, it defies common sense, it defies the evidence, it defies what he knew how things were supposed to work. Mr. Fleming never once communicates with Tony Satterfield about the change of the PR, never once communicates with Tony Satterfield about a recovery of $500,000. Instead, he deposits the check that they had pre-made out to Chad Westendorf even before the change of PR. And then Mr. Fleming prepares a petition for approval of wrongful death settlement and an order. And that order says that there's going to be $166,000 in attorney's fees, which is the standard percentage. But that's not what happened. It also has in there, on the nose, $11,500 in expenses, which are completely fraudulent. Didn't exist. And what Mr. Fleming's own staff revealed is that in the Satterfield case, every step of the way, normally when they're preparing the disbursement sheets, they're getting all the receipts from the expenses, depositions, travel, mediator expenses, all that she's getting them all together and she's itemizing them and doing all the math for that disbursement sheet for the client to sign. And instead, no, stop. This is the numbers I want you to put down. That was Mr. Fleming doing that, not Alec Murdaugh. That's plea exhibit 9, Your Honor. January 7th, 2019, they get Chad Westendorf to sign a disbursement statement. Again, it's got those fraudulent expenses of $11,500 on there. This time it does indicate that the attorney's fees is $50,000. Again, cutting the fee, but never telling anybody, telling Mr. Westendorf, hey, let your clients know what a great attorney I am. I'm cutting my fee in half, or less than half. Out of the goodness of my heart. Never says that. What does that tell you, Your Honor? Why would somebody do that and not let the people who are supposedly benefiting from that know? The only reason you're doing that is because you're creating a delta for your co-conspirator to steal. Mr. Fleming, when that check gets cut, Mr. Westendorf's like, what do I do, man? Tell me what I need to do. And he says, I'll handle the disbursement. Mr. Fleming does. I'm going to pay some medical expenses, which he never does. Absolutely never does. January 17th, 2019, just a week later or so. That first money has come in. It's in Corey Fleming's trust account. And this is the first evidence where we see Mr. Fleming be like, yeah, that's a lot of money. I think I'll just go down and take some of it. And he goes down to a staff member and says, cut me an $8,000 check made out to me from the trust account of money belonging to this family and say it's expenses for the case. They're completely fraudulent. We can look at Mr. Fleming's accounts. He may not remember why he did it, but we can see why he did it. Bank records tell a story. And we can see the balance in his account, how low it was, and we can see that money come in, and it immediately goes to pay a mortgage and other personal expenses. Needed the money, had their money, and just walked down to a staffer's desk and said, cut me a check. Stolen. Ultimately, there's a mediation. Mr. Fleming is there, and Mr. Murdaugh is there, and ultimately they collude during the course of that. And Mr. Murdaugh is like, Bo, I got to get me something out of this. I got to get me something out of this, Corey. They accept an offer, settlement offer for $3.8 million. Does Mr. Fleming tell this family about such a momentous event? No. Does he try to communicate with them? No. Does he tell them, oh, I got y'all $3.8 million. I can take $1.4 million in fees from that, and I'm going to cut it in half out of the goodness of my heart. Does he do that? No. Why? Because he is creating that delta for his co-conspirator. Because they have the patsy in there so that they can get the scheme done. And they tell Mr. Westendorf again, we got it. Mr. Fleming says to Mr. Westendorf, I'll take care of the disbursements. $3.8 million come in. That's a big day. And Mr. Fleming doesn't wait a moment. Because on March 26th, he goes right back down to his staffer and says, hey, cut me a check for $8,500 for expenses in the estate of Gloria Satterfield, which are completely fraudulent. Couldn't wait one day. Let me go ahead and put $8,500 in my pocket. And again, we can look in his account and see how low his balance was, and we can see immediately the vast majority of that money, he has to make a payment of taxes. Again, there's no illusion about the motive here. He was broke and he needed the money, so he just stole it from this family because he had it in his trust account. Well, they got $3.8 million. And again, if you have any illusions about Mr. Fleming believing that when he cut those checks to Forge, that $2.9 million check, which is the next check that he cut to the single word Forge, that he really thought that every dime of that money was going to this family, well, the emails prove otherwise. And these are crucial, Your Honor, States Exhibits 13 and 14. Because the adjuster at Nautilus is like, I don't understand. Tell me how to cut this check. Is he doing a structure or not? But does he want a single check? We need to know, because if he's going to do a structure, he has to do it this way. And Mr. Grantland sends it to Mr. Fleming, says, what do you want me to tell him? And Mr. Fleming's like, well, says some things. He's like, well, I got to check with Forge, which is a lie, because he's not dealing with real Forge at all. And they don't have an answer. So, again, Mr. Grantland sends the same question that the adjuster from Nautilus is saying, how are we cutting this check? This is the email. I need some clarification here. If he has a structure, don't we need to wait for information on the structure? Is he wanting us to fund the structure? Or is he funding the structure? If he wants us to fund the structure, it must go through Ringler. If he doesn't want us to fund the structure, does he want the funds to consist of a single check in the amount of $3.8 million payable to Chad Westendorf as PR? And the Nautilus attorney forwards that to Fleming and says, let me know what I need to tell her. And eventually, on April 1st, 2019, Mr. Fleming says, okay, standard check. Chad Westendorf as PR and MK&F as attorneys. There was no structure, and Mr. Fleming knew. Aside from the fact that's not how it works. He couldn't take the money directly. You can't do a structure in the traditional sense that way. These emails prove it. He tells them standard check. And of course, that check is cut to his trust account. In May 9th, 2019, Mr. Fleming tells the Nautilus attorney, you don't have to come to the hearing. And then, Your Honor, this is State's Plea Exhibit 18, and this is a crucial thing as well that refutes Mr. Fleming's claim that he was only doing 58 miles per hour. Because again, his staffer starts to prepare a disbursement sheet, and she's searching for legitimate expenses, and she puts on there that there were disbursements to Forge for Lloyd's of London of $403,500, and there's disbursements to Nautilus of $2.9 million in change, and also puts on there the fees. And Mr. Fleming, not Mr. Murdaugh, Mr. Fleming goes down and tells his staffer, no, stop. Stop. Don't do it like that. Put these numbers down. Without any support, just tells her, no, I want these numbers. And that's in Plea Exhibit 19. And what's crucial about that, Your Honor, is that any reference to Forge is removed. In the one they actually give to Chad Westendorf. It's removed. And what's also crucial about that disbursement statement, Your Honor, State's Plea Exhibit 19 that they give to Chad Westendorf to sign is that it's got the full fee, collective fee between the two recoveries of $1.4 million on there. It lists that they're taking the full fee. That's what he tells the PR. He doesn't tell the PR, oh, by the way, out of the goodness of my heart, please tell the boys, I'm such a great lawyer. I'm so generous. $600,000 is enough for me. Cut it in half. He doesn't do that. No, he puts the entire fee on that. And why does he do that? He does that to create the delta for his co-conspirator to get his half of the fee split. There's no other reasonable explanation, Your Honor. Particularly when you look at the entirety of the course of conduct of these two men together. So, Mr. Fleming takes his fee of $600K for Nautilus and $50 for Lloyd's, and then causes that check to be made out to Forge and has it delivered ultimately to Mr. Murdaugh. That's in May of 2019. A number of months go by, and they still have money that they've retained belonging to the Satterfields. Mind you, the Satterfields don't have a dime. The Satterfields don't even know that one solitary cent has been recovered on their behalf. They don't know any of that. And over $4 million has been recovered in their behalf. And no one has told them a thing. Certainly not Mr. Fleming, whose responsibility it was. And he can't hide behind the fact that, oh, well, I was dealing with Chad Westendorf because he specifically didn't tell Chad Westendorf what to do, and he specifically participated in conspiring to put Chad Westendorf in there as PR as a patsy to keep the truth from coming out to these boys and this family. But still got money in the trust account. Mr. Fleming needs some walking around money. So January 2020, goes on down to a staffer and says, hey, cut me a check for $9,700 out of the Satterfield money from the trust account. Make it again payable to me. This time he didn't even, it's gotten so easy, he didn't even bother to try to put on there expenses for the estate or anything like that. There's just no justification. Just cut me a check out of it. $9,700. And he spent that money on personal debt. Again, if we have any illusion about what Mr. Fleming knew when he was colluding with Alec Murdaugh, or that he really thought that this money was going to the family, despite this entire course of conduct that was specifically designed to keep them from knowing a thing, there's still money in the account. 17 months go by, Your Honor. In October of 2020. And a couple things happen. The first thing is that Mr. Fleming signs a stipulation of dismissal for the case. And do they involve the Nollis attorney? Does he sign it? No. The only other person that signs it is Alec Murdaugh, the defendant himself. And concurrently with that, at the same time, the next day, October 6th, 2020, he causes another check to be cut from his trust account made out to the single word Forge for $118,000 and has that delivered to Alec. Now, what's interesting, Your Honor, is that when we look at that $118,000, and then actually there was still $113,000 that was remaining in his trust account when all of this stuff came to light, it totals $231,000, which in their sentencing memorandum they admit, they attribute that to Mr. Fleming. But how in the world can they attribute that $118,000 in October 2020 when he disperses that to Alec to Forge, and they sign that stipulation of dismissal with the defendant himself? How can he say that he knew that that Forge check was bad, but not the other Forge checks? The whole thing stinks to high heaven. The whole thing is done underhanded. The whole thing is done to prevent the system from knowing what was going on and to prevent this family from knowing what was going on. It was designed that way, and he was part and central to it, crucial to it, from the very beginning. Mr. Fleming might try to tell you, or his counsel, that when everything came to light, he was appalled. And eventually, as everything came to light, and actually after requests were made, or demands were made, disgorged his fee. Well, Your Honor, you don't get to rob a bank, run down the road, and the police catch you, and say, oh, here's the money back, we're cool, right? It's not how it works. And what he didn't do was say, oh yeah, by the way, I've been stealing checks from these accounts for almost a decade. He didn't come clean with that. It took the state grand jury to catch him red-handed for him to finally recognize that he was caught. And he could no longer claim to be, like so many other people, yet another poor, unfortunate victim of Alec Murdaugh. No, he was the co-conspirator. Your Honor, when we total up the losses attributed directly to Mr. Fleming's conduct in this case, between the Satterfields and the Pinckneys, that total is $3,725,203.85. Everything about this case and how it was done shows you that his Johnny-come-lately mitigating, I'll only admit to what, the very minimum, was doing 58 miles an hour. Everything about this course of conduct refutes that. Aside from, Your Honor, just good old plain common sense. Common sense about how this was done. Your Honor, I'd like at this time, if it's up to the court, to let some of the victims address the court, and then I'll have a few more comments before I will yield to the defense presentation. And I will also request the opportunity to speak after the defense presentation to address any issues they may raise. But at this time...
Very good. Before you do that, let's all just take a moment to
Yes, sir.
stretch for a moment. Everybody take a moment. Stand. Came from St. George. We were in Barnwell. I thought the reporter said she was coming down last night. Yeah.
Yes, I don't know. I just
Yeah.
received that.
She was leaving Barnwell yesterday to come here. Notice. But you
You put something on you?
Okay, we'll come to order.
Thank you, Your Honor. With court's permission, I believe our first victim who would like to address the court is Mr. Tony Sackford.
Okay.
My name is Tony Sackville. So first, I just want to say this is actually a life lesson to everybody. You know, a lot of times, we think our actions do not affect other people, but they do, bad and good.
Mr. Satterfield, if you will address your comments to me.
Oh, I'm sorry.
Yes, sir.
Same thing I'd like to say is that my answer still stands. I still forgive Mr. Fleming. And as far as the sentencing goes, that's left up to you, Your Honor. That's why, you're in this situation to give that, not myself. And the main thing, I know I'm going to get asked, what do you think? How do you think it went? Me personally, my honest answer, I don't care. I just want God's name to get the glory for it. I just want, His name to be called.
All right. Thank you.
Junior Hadwin, Gloria's sister.
Good morning, sir.
Good morning.
First of all, I would like to say that our family, of course, was affected in a tremendous way that hurt us deeply because we not only trusted the system, we thought what was family to us. And yes, Mr. Fleming did wrong, and he admitted what he done. And yes, he should be punished for what he's done. But we do forgive. As a Christian family, we believe in forgiving. But it still does not take away the hurt that he caused us. And also, we feel like Gloria did not die in vain because her case actually brought out a lot of other corruption and dishonest deeds that were done to other people. And we feel like that it is being served now. Things are coming to light that should have been brought to light a long time ago. And I want to thank the state for all the work that y'all have done to bring everything to light. And Mr. Wardage, you've done a fantastic job this morning, bringing out everything and actually simplifying a lot of stuff. And thank you very much. Judge, thank you so much. We trust in you and your honor that you will make the right decision in your sentencing. And again, we do forgive Mr. Fleming.
Thank you.
Thank you, Eric, and Ronnie also.
Judge Newman, my name is Eric Land, and I have the honor of speaking on behalf of the Satterfields.
Yes, sir.
I also have the honor of speaking as a lawyer of 35 years on behalf of other lawyers. Lawyers who are overwhelmingly honest and do good by their clients. The license we have is a sacred trust. It's a trust that we have to help our clients. It's not a ticket or a license for us to take from our clients. And, you know, it's natural that we want to dislike criminals. We want to dislike people like Mr. Fleming. But you're going to hear from a courtroom of people that he's a nice guy. But unfortunately, nice guys sometimes do criminal activity. And so you have to balance today not only the sentencing of the man, but sentencing the crime. Because our profession, a profession that I love, a profession that you love and dedicated your life to, has been stained. And you understand that when things like this happen, when lawyers take money from their clients, especially in this case when it's millions and millions of dollars, that the jokes multiply by 10. I've never liked lawyer jokes. I don't like people mocking lawyers. I don't like the nasty things that sometimes that people say. But one criminal activity in this type of case germinates and hurts our profession for a long, long time. Now, I think it's important that you do understand that Mr. Fleming knew exactly what he was doing. He is a plaintiff's lawyer. He has settled plaintiff cases before. And in this particular case, he worked with the party he was making a claim against. It's impossible to get your arms around that. He didn't have client permission to do that. He never had a fee agreement to do what he did with the client. We know, and Your Honor knows, the contingency fee agreements have to be in writing. There was no contingency fee agreement. There was no joint sharing agreement with Mr. Murdaugh, even though he couldn't do it to begin with, to disclose to the client. There were no disclosures at all to the client. He met Tony Satterfield as the PR one time. There never was any communication. I've been suing lawyers for probably 30 of my 35 years. I have never seen every single dollar taken from a settlement. You see sometimes that it's, a portion of it. But in this case, they took every single dollar and never communicated with Tony Satterfield, never communicated with Brian Harriet, his brother. They recovered millions of dollars. They should have been applauded for recovering that on behalf of Gloria Satterfield. You're going to hear that Mr. Fleming said he won't use the word victim like he used for the last 2 years, where he said that he was a victim just like everybody else. But you're going to hear kind of off words. They're close, maybe a first cousin of victim. You're going to say he didn't understand what was going on. Sure he did. If you're going to do a structure, Your Honor knows that you have to have insurance policies that represent that structure. Your Honor knows that when you have two beneficiaries of that structure, there would be two separate policy numbers, one for Tony, one for Brian. Your Honor knows that if you're going to send a check to the structured insurance company, you got to allocate. You can't just send a check for $2.9 million to an insurance company and not have any reference on the check that this amount is for Brian and this amount is for Tony, and it needs to be deposited in this account and applied to that insurance policy number. None of that was done. Mr. Fleming sent the check without a cover letter. No letter to to Forge to say, hey, this is how it's allocated. It was sent to a P.O. box in Hampton, South Carolina. Every plaintiff lawyer knows that Forge is in Columbia, South Carolina, and Atlanta, Georgia, not in some P.O. box. More importantly, the 3 checks that Mr. Waters described were signed on the back by Alex Murdaugh himself. It says, DBA, Alex Murdaugh, DBA Forge. Hey, that would give it away, right away, that he was not doing a regular structure. This is a case, Your Honor, that was really 2 letters that were sent. And, you know, magically, $4.3 million was produced. A tremendous amount of money. Not that Gloria or any other person isn't worth that. But that is a very large settlement. A settlement that would probably be 3 times larger than most other counties in our state. And Mr. Fleming took $11,500 in expenses in a case that there was no filing fees, in a case that there was no depositions, in a case that there was no experts. He had a signed disbursement sheet in May of 2019, signed by a judge, just like you. And when you sign an order, we have to follow it. But he took that order, and he never filed it with the clerk of court, despite getting a letter from the insurance company that said, before you disperse on that check, make sure you get a signed order and file it. But what did he do? He didn't file it. What did he do? He went into the chambers of Judge Carmen Mullen, down here, and he told her, look, we've made a decision to change the caption on the case. Instead of it going to be the estate of Gloria Satterfield decedent versus Alex Murdaugh, we've decided to take Mr. Murdaugh's name off the caption. No, I can't do that without Your Honor's permission. But that was done without a court order. And then they took off Gloria Satterfield estate and decedent to make it look like she wasn't even dead at all. And what did they do? They came back after they got that signed order, after they told Judge Carmen Mullen, this is how we're going to disperse it. There was no reference that they were going to send $2.9 million of the $3.8 million to Forge. They were going to disperse it to Brian and Tony. What did they do? They just totally disregarded that order and started cutting checks, a check cutting party on May 14th. No court permission. You know, if I'm going to deviate from the order you signed from the disbursement sheet, I better come back before Your Honor and do that. No permission from the court was done. Nothing. No communication with these clients. This young man here, who's a vulnerable adult, who's in his 30s, lost his mother. Alex Murdaugh and Corey Fleming knew that his trailer was being foreclosed on, and he didn't have the money. And they're sitting on $4.3 million of their money while he's getting pushed out on the street and loses his mother's trailer. That was all she had. That was all she had. What happens? He keeps money in his trust account. Judge Mullen signed an order that said, you disperse every single penny in your trust account. As Mr. Woodard said, he kept it for 18 months in a case that was over with. In a case that he went before Judge Mullen and said in May, I need $105,000 of additional expenses that we spent. That's going to be dispersed. Again, in a case that no lawsuit, no depositions, no expert witnesses, and it was $105,000, not $105,172.27. It was just blatant thievery in open eyes of everybody except the 2 most important people that we work for, the clients. And what happens? Like Mr. Woodard said, on October 12th of 2020, 17 months later, they decide we're going to cut some more checks. And you know what? We better get this case off the docket. So Mr. Fleming and Mr. Murdaugh decide to sign a stipulation of dismissal. Mr. Murdaugh had a lawyer, John Grantland, who represented Nautilus Insurance Company. He wasn't contacted. Mr. Fleming knew that there was a lawyer involved. and they dismissed the case. Yet he sits on another $113,000 for another year, all the way up to the fall of 21, when he finally was caught, when I finally surfaced on September 7th with my partner, Ronnie Richter. Now, I will say this. Of all the defendants that we got money for, and we can announce that we've recovered more than $7.5 billion for the Satterfields from a number of sources. Mr. Fleming was the first to come forward in the fall of 21. He did disgorge himself of the $680,000. His insurance company did pay the full value of his policy. He did finally disperse the remaining $113,000 in his trust account to my clients, and there was additional monies paid by his law firm. But the last thing I want to add, Your Honor, is he fought these charges. He wrote a letter to the Georgia bar. Now, unlike our South Carolina bar proceedings, the Georgia bar proceedings are over. I was a complaining party because whenever I bring a claim against a lawyer for malfeasance or theft, it's my duty to notify the bar, and so I notified South Carolina bar and notified Georgia bar. So I'm part of the process in Georgia. They want to hear from the complaining party. So when Mr. Fleming filed his response to the Georgia bar complaint, I got it. It was a 57-page response that he did under oath. Swore to tell the truth, just like he's going to do when he stands before you today. You know what he told the Georgia bar? I was a victim of Alex Murdaugh's theft. I had no idea what he was doing. I was duped just like everybody else. I didn't understand how to do the structure of Forge. Mr. Wooders shared with you that February 2017 letter. It was crystal clear, and you'd already done structures, but even if you haven't done structures, it says you can never get the check as the settling plaintiff lawyer. It's got to go from the paying insurance company to the annuity insurance company that's going to issue the structure. He already got the checks. Like Mr. Wooders said, Forge doesn't get money. They're a broker. You don't send money to Forge. It goes to an insurance company. But in that 57-page response, he says, I had no idea what was going on. He didn't, you know what he said? I stole from my law partners. I didn't steal from the clients. When I stole those 3 checks of the $9,500, the $8,500, the $9,000, I was stealing from my law partners. By the way, Judge, you read the rules of professional conduct, we don't have license to steal from our law partners either. That's another no-no. So, I know you're a just judge. I watched you. I've watched you your entire career. I know how much you care about our profession. I certainly know how much you care about our state. And this whole Murdaugh, Fleming, Lafitte debacle has stained our state. And I'm going to leave with saying one thing. The hand of one is the hand of all. And Mr. Fleming is pleading guilty to every single charge, which means every single element of every single crime and every single fact that Mr. Wooders has announced form the basis of those. So I ask you to do your duty, to look at this as these are state court independent charges, not to look at, well, he's been sentenced in federal court, so that kind of takes care of it. These are claims that our citizens, the state of South Carolina, brought through a grand jury, advanced with our dollars through the South Carolina Attorney General. And I'm confident that at the end, you will give that proportionate, just sentence that deals with retribution to punish Mr. Fleming appropriately, but not overly so. Deterrence to tell me and every other lawyer, you cannot steal from your clients. Your duties are to your clients, not to yourself. Thank you.
Thank you.
Your Honor, I think our final victim presentation before I conclude my initial remarks comes from Mr. Bamberg, who again represents Pamela Pinckney. And I think it's important to point out that while there has been a resolution in federal court, that was only on indicted Satterfield conduct because of the statute of limitations there. And I know that Mr. Bamberg will address, of course, that we are here today for the first time for accountability as it relates to Ms. Pinckney alone. But Mr. Bamberg, I'll turn it over to you.
Thank you, Your Honor.
Yes, sir.
Creighton is correct, Attorney Waters is correct. On behalf of Ms. Pinckney, she wanted to be here, but she had a procedure on Monday, a medical procedure, and she's been dealing with a lot of pain since. So I'm here on her behalf, and that really speaks to the type of people who are victimized. We had to sit through a federal case through the United States of America's court system and hear about things that were done to the Satterfields. And Ms. Pinckney, her family supports the Satterfields. What happened to Ms. Pinckney, what Mr. Fleming did to Ms. Pinckney was mentioned in the federal case. However, due to statute of limitations, she was not able to seek justice, criminal justice through that. That's what today is for. It's her first opportunity after well over a decade. Your Honor, I want you to understand a little bit about what Ms. Pinckney went through. When we think about white-collar crime, a lot of times people talk about it as though it is victim bliss, that it just involves the almighty dollar, and that's not the case. This was a horrendous accident. Not only did Ms. Pinckney shatter most of the bones in her body, there was a very extensive recovery process for her. But she had to deal with injuries to other people that she cared about. For example, her niece, who in addition to numerous physical injuries, lost the vision of one of her eyes. And her son, Hakeem Pinckney. And Hakeem, Ms. Pinckney poured her soul into that young man. And he lost his hearing at 3 years old. He struggled with that. And she never gave up on him. She poured into him. He ended up graduating from the South Carolina School for the Deaf and Blind. And shortly after graduating, he had all these dreams and ambitions. And during that accident, that fateful day, this young man was rendered quadriplegic. He was unable to move anything below his neck. He was on a ventilator to breathe from him. He relied on an electric machine to breathe from him. And because he couldn't move, he couldn't sign language, and therefore he could not verbally communicate. And she never gave up on him. Hakeem died, and it was very tragic. His ventilator was found unplugged. So, it's hard not to get teary-eyed when you think about what he went through, but here's a young man who cannot hear, he cannot speak, he cannot move, and now he cannot breathe, and he can't tell anybody. He became a prisoner of his own body. And Ms. Pinckney was aware that that is how her son died. And instead of being a supportive lawyer, instead of showing compassion and care, empathy or sympathy, he could have said to this woman, I am so sorry for what you went through. I want to own up to the fact that I took some of your money. No, he didn't. In fact, they took the money and they flew to the College World Series to watch baseball. Meanwhile, this woman is still recovering. She's still dealing with the loss of her son. And no one cared. And I've said this before. Ms. Pinckney, myself, the Pinckney family, everyone believes that Mr. Fleming regrets everything that he did, not just to them, but to the Satterfield family over a decade later. Nobody doubts that he regrets it. It's hard to not regret your decisions when you're sitting there. I think everybody regrets that except complete sociopaths. We do not believe that he is remorseful for what he did. And there is a difference between I regret getting caught and getting in trouble and true remorse for what I did to you. When we hear these numbers, Your Honor, and we hear numbers like $500,000, we hear numbers like $3 million, we hear about total amount of money stolen, we have to remember that where we come from, and myself, Ms. Pinckney, that I'm talking about geographically, where we live, we're $8,000 check, $9,600 check. Yes, for privileged attorneys and others who either have been very blessed, very successful, or work very hard to get there, it may not sound like a lot of money when you hear about $4 million get taken. Minimum wage in our state, Your Honor, $15,850 if you're making minimum wage. That's how much you earn working for a year. Some of the money that Ms. Pinckney lost, she would have to work over half a year to earn and then pay taxes on it. This is not a small amount of money. This is not a victimless crime. Your Honor, we trust the system. And I echo much of what Eric Bland said, that this was a black eye to attorneys. It was a black eye to the legal profession. It was a black eye to our state. But it was a dagger in the heart of the clients who trusted their lawyers. Mr. Fleming knew he wasn't supposed to do it. We firmly believe, and I've had in-depth conversations with Ms. Pinckney about this, it wasn't until the federal government came, and now there was this window of opportunity to possibly serve a sentence in federal court, that Mr. Fleming was then willing to say, yes, I did X, Y, Z. Up to that, there was no, yes, Ms. Pinckney, I took your money. That wasn't represented to the ODC ethics, as you heard Attorney Bland reference. It was deny, deny, deny. And one of the most difficult things for Ms. Pinckney and every other victim is having to know that you are truly a victim of bad acts from bad actors, and then hear those same bad actors who took bad acts say that they're a victim. It's demeaning, it reopens old wounds, and it's highly offensive. And in the world of white-collar crime, Your Honor, if we talk about Wall Street, it's not necessarily people stealing your money and you willingly give it to the investment bankers. No one willingly gave Corey Fleming their money. He deceived them. He took it. You know, and I know that there will be folks who will speak very positively about him. And we have no doubts that to a lot of people in his life and over the course of his life, Your Honor, he was an amazing person to them. He did do wonderful things to them. He was very giving to them. But he's not here today sitting in judgment of Your Honor for how good he was to everyone else. He's sitting in judgment for pleading guilty, element for element, charge for charge, to how bad he was to Ms. Pinckney and Satterfield. And we would ask that, Your Honor, take all of that into consideration. This is their one chance after over a decade to get justice, Your Honor. And we ask that this court impose a sentence that is not only sufficient to, again, punish Corey Fleming. He's got a federal sentence again, but it has nothing to do with Ms. Pinckney. He has not been punished for that. We ask that you sentence firmly to not only punish him for that, but to also deter not just lawyers, but anybody who owes a fiduciary duty and people rely on you. Don't steal from them. We're not expecting people to be perfect, but we are expecting you to be a decent human being. And if you're a lawyer and you take that oath that we all have to take, that you take that oath seriously. And it doesn't matter whether you personally have hard financial times or not. The saddest part, as an attorney who's gotten to know Ms. Pinckney, Your Honor, is knowing that even with the horrible death of her son, even with her own broken bones, her own medical bills, is that Corey Fleming needed money, Your Honor, and asked her. I guarantee you she would have gave it to him. That is the type of person Ms. Pinckney is, and that is who we victimized, Your Honor. Thank you so much for your time.
Thank you.
Your Honor, I just have a few more brief comments, and then I will yield to the defense for their presentation. Again, would request the opportunity to speak and reply after they have presented. Mr. Bamberg touched on this, and I know Your Honor has been presented a lot of letters, and I know that there's support out in the courtroom for people who have known Mr. Fleming, and I'm sorry. I'm sorry to them because they've been victimized by this too, because they have to be here. And they're put in this position. And I'm sorry that they have to go through this because I have a job to do. These people on our team have a job to do. The law enforcement officers here have a job to do. And the reality is that to be a con man, it depends on trust. It depends on reputation. It depends on the inherent credibility that comes with having a law license on your wall. It doesn't work otherwise. It depends on someone who doesn't have a prior record, which Mr. Fleming doesn't. That's how con men work. That inherent trust and reputation is what they tread upon for this scheme. It doesn't work without all these good things that people are going to say that they believed about Mr. Fleming. It's the only way a con man can succeed is if people trust him. And they did. And he betrayed them. You might hear a little bit about the process, and you may hear essentially that the state, the Attorney General, the State Law Enforcement Division are being unreasonable because we refuse to accept and just check the box that Mr. Fleming was only doing 58. Instead, insisting, because of the hard work that was done by all these folks, to really dig deep and uncover the truth. The truth matters, Your Honor. The truth about what happened to the system matters. The fact that he was doing 90 miles an hour matters. It matters. It's not enough to just say, I did 58, and we'd say, okay, that's fine, we're done here. What really happened matters. When it affects the integrity of the system, when it was abuse of the system, of the very courtroom in which we are in right now. Your Honor, independent accountability for his abuse of his state law license and state court actions is warranted in this case. Consecutive time is warranted. Consecutive time is warranted for the extent of the reality of what Mr. Fleming did to the Satterfields exposed in this courtroom. The 90 miles an hour. Independent accountability is warranted for that. Above and beyond whatever was before. I'll give Mr. Fleming credit for pleading guilty, but he doesn't get credit for the delta, for the difference between 58 and 90 miles an hour. And his inability and refusal to admit to that, to only admitting to the most mitigating version of events that he can no longer deny because he's caught red-handed, that only should get so much credit, Your Honor, and there needs to be independent accountability for the truth of what happened to the Satterfields, above and beyond any other proceeding that has nothing to do with what happened here, or what this proceeding was. Independent accountability is warranted for Pamela Pinckney, who, as Mr. Bamberg said, has convictions relating to the conduct victimizing her in this court. And while you may hear that in another proceeding they rolled that into a PSR, that's not the same thing, and we don't even get that. I don't know what's in that thing. It doesn't matter, though. A lawyer should not get one-stop shopping for victimizing multiple clients over the course of a decade. It's not buy one, get one free. There should be independent accountability here today, consecutive accountability for Ms. Pinckney. He should not get buy one, get one free. And independent accountability is again warranted for the state judicial system itself. It must defend itself and have its own independent accountability and not allow someone, when the state is unhappy with 58 miles an hour, to just make a deal and that be the end of it. I ask Your Honor for consecutive sentencing. I ask Your Honor that even if you run sentencing for the Satterfields concurrent to anything else that happened, that any sentence for the Pinckneys be consecutive. I ask Your Honor not to let Mr. Fleming, who I think we have established has not completely come clean with the reality of his behavior and only admitted to what he's admitting to now because he got caught red-handed.
What is his exposure for in the Pinckney case and the Satterfield case?
Stand by, Your Honor. So the total exposure between the two is 195 years and fines up to over to $8,090,863.90 plus discretionary fines. Your Honor, if we look at the Satterfield crimes, count 10 is a criminal conspiracy, which is 0 to 5. We have 3 counts of insurance fraud, $50,000 or more, which is 0 to 10, plus fines of $20,000 to $100,000. Counts 13, 17, 21, and 30 are breach of trust with fraudulent intent, $10,000 or more, which are 0 to 10, plus fine in the discretion of the court. Counts 14, 18, and 22, value of money laundering, value $100,000 or more, carry a potential sentence of up to 20 years, Your Honor, and a fine not to exceed and/or a fine not to exceed $250,000. Counts 23, 25, and 27 are breach of trust with fraudulent intent, value $2,000 to $10,000. That's 0 to 5 plus fine in the discretion. Counts 24, 26, and 28, 3 counts of money laundering, value more, value $300 to $20,000, which is 0 to 5, and/or fine not to exceed $250,000 or twice the value of the transactions. And then count 29 is computer crime, value more than $10,000, which is a 0 to 5, and/or fine not more than $50,000. Your Honor, that is the Satterfield case. For the Pinckney case, 2022 GS 4702, again, both of these indicted by the state grand jury back in early 2022. We have counts 5 and 9, which are breach of trust with fraudulent intent, $2,000 to $10,000, which are 0 to 5 plus fine in the discretion, or fine in the discretion. Counts.
You said 0 to
0 to 5 or fine in the discretion for that one, Your Honor. Count 6, breach of trust, $2,000 or less. That's actually a 30-day offense, Your Honor, or a fine not more than $1,000. That would have been one of the Crossland checks, which was like $1,400. Count 7, which is criminal conspiracy, that's 0 to 5. And count 8, breach of trust, $10,000 or more, which is 0 to 10, or fine in your discretion. Again, the state would submit that no matter how you stack them, even if you run certain ones together, that there needs to be independent, consecutive accountability from one to the other. And that there needs at a minimum to be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinckneys. So that Mr. Fleming, for decades, almost a decade's worth of conduct, doesn't get buy one, get one free. Thank you, Your Honor.
all right. Ms. Barbier?
Thank you, Your Honor. May it please the court.
Yes, ma'am.
Your Honor is aware that on August 21st, I filed with the court an initial sentencing memorandum, and in that sentencing memorandum laid out for Your Honor some of the background of the investigation, joint and federal investigation, and then also talked a lot about Mr. Fleming's life, his community involvement, the things that bring him to you today as a whole person to look at. And then, Your Honor, following the guilty plea, which is when we heard a lot of the same information that we heard today from Mr. Waters, on September 12th, we filed a supplemental sentencing memorandum. And in that sentencing memorandum, we addressed a few of the factual issues that we had some discrepancies with. And then yesterday, I received a response from the state. And I want to thank the state because they responded very quickly. And I think that what I gleaned from their memorandum is there's very little that we disagree with in terms of the responses they made to our sentencing memorandum. First, Your Honor, I took issue with the fact that they said that Mr. Fleming had invited Mr. Satterfield into his office and changed the personal representative execution forms. I pointed out the evidence simply doesn't support that, and Mr. Waters agrees with that. And we're not saying it's material to his guilt, but we wanted to point that out because it was factually inaccurate. Secondly, Your Honor, with respect to the caption that was created on the stipulation of dismissal, the petition, and the order, that was not done by Mr. Fleming. Again, that's not material to his guilt, but it's something that I wanted to point out for the court was not accurate. Regarding the check that was written on the Pinckney settlement proceeds, the $89,000 check, Mr. Waters stated during his plea factual basis that had been made out to Ellick personally. It was not. It was made out to the Murdaugh firm at that time. Again, that's not necessarily material to his guilt, but that was a factual inaccuracy that we wanted to point out. Most importantly, Your Honor, and I appreciate the state's candidness with the court on this issue, they, right out of the gate in their sentencing memorandum said, and I'm quoting them because I don't want to misspeak on their behalf, they said the state does not allege that Fleming necessarily knew the specific particulars of Murdaugh's fake Forge account or that Murdaugh intended to steal all of the money given to him. Indeed, the state has consistently accepted that Fleming might not have expected Murdaugh to steal all of the money. And that's an important fact to Mr. Fleming, Your Honor. That's an important fact that he wants you to know, and that, again, was reiterated today by Mr. Waters in his closing argument, or his fact, whatever you want to call it, that he made today. And so we appreciate those two concessions. Those are very important for Mr. Fleming to have on the public record, both for him and for his friends and supporters to understand. And so I appreciate the state's response and the prompt response of that nature. With respect to the Forge issue, Your Honor, I know that Mr. Bland and Mr. Waters have made a lot of comments about what Mr. Fleming definitely knew or should have known or did know and what he did. We pointed out in our sentencing memorandum a couple of things that I think would be good to reiterate at this time. Your Honor's heard, I'm sure, a lot about Forge from the other trial that you had and from the information in that trial that was put forth about Forge Consulting. Your Honor's probably aware that the fake Forge account was created in September of 2015, which is years before the Satterfield case came to be. The account was started at Bank of America, and it was titled Alexander Murdaugh DBA Forge. The account clearly had no affiliation with the real Forge Consulting. But Mr. Murdaugh was the only authorized signer on that account. He's the only one that had access to it. He's the only one on the signature card. And unbeknownst to Mr. Fleming and to a lot of other people that Your Honor himself heard from during that murder trial, good people, people that had known Mr. Mr. Murdaugh for 40 years. And the crux of the testimony, Your Honor, I don't have to tell you because you had front seat to that trial. But the crux of that testimony was that Mr. Murdaugh habitually lied to everyone in his personal and professional life. He lied extensively to his law partners, to his accounting department, his CFO, his family, his office manager, his banks, his creditors, his opposing counsel, to judges, and court personnel. And, Your Honor, during this time period, I think it should be known, Mr. Murdaugh was the president of the Trial Lawyers Association. He was by many accounts, a respected member of the bar, and a lot of people, including Mr. Fleming, were stunned to find out that he had been stealing millions of dollars, diverting it into this fake forge account. Ms. Seckinger, I recall, her testimony was that the firm had these checks being written to forge for years out of their trust account, and they didn't know he was stealing. There were the bank statements from the fake forge account were in Mr. Murdaugh's office. No one caught that. No one caught the fact that these checks were coming back with his individual signature on it. Mr. Fleming never saw those types of checks come through his office. I cited to the testimony of Mr. Cope, a partner at the Murdaugh firm, who recounted the story of when he told Mr. Fleming about this fake forge account and about what had transpired at the firm and about the fact that they had caught Mr. Murdaugh stealing money from the firm. And I cited to you, his testimony, and the crux of his testimony was that Mr. Fleming immediately brought up the Satterfield case. He was calling him about a completely different matter. Mr. Fleming's the one who brought up the Satterfield case and said, "Oh my God, we had the forge account in the Satterfield case and it was for millions." And Mr. Cope's clear impression was that Mr. Fleming was shell-shocked. And I say this, Your Honor, and I give you this information not to minimize or downplay or excuse any conduct of Mr. Fleming, okay? Because what we are here today for is a sentencing. As Your Honor knows, Mr. Fleming has pled guilty to each and every count that he's been charged with. That doesn't happen very often. He pled guilty to, all of the conduct in federal court, and he's pled guilty in this court to the conduct. And so he's not here to make excuses for himself or to call himself a victim or to place the blame on anybody's shoulders other than his own. But I have to take issue with the theme of Mr. Waters' closing argument during this process here. He says that Mr. Fleming's guilty plea is the equivalent of pleading guilty to speeding at the rate of 58 miles an hour in a 55-mile zone when he's really going 90. And I have to say, with all due respect, this analogy is a gross mischaracterization of Mr. Fleming's guilty plea and the illegal conduct that he has fully acknowledged. He's pled guilty to each and every count in state and federal court, and that's a total of 24 felony counts. And that's hardly a speeding ticket. And he has not run away from his guilt in this case, not in any way whatsoever. He has, as Mr. Waters would have you believe, he's not run away. He has confronted his actions. He has stepped up to the plate. He has fully acknowledged that he was wrong, that he committed illegal acts, and that he is guilty. And he can only give this court and he can only give the government the facts as he knows them. That's it. He can't make things up about himself or other people. He can't say things that aren't true. He has acknowledged his guilt, though. And as Your Honor's aware, that is not the case in most cases. In most cases, first of all, people aren't always prosecuted in both state and federal court, even when there's concurrent jurisdiction. Many times one prosecuting entity defers to the other. That's generally the normal course of business. Your Honor was a prosecutor. I was a prosecutor. That happens all the time. And that's not the case here, and I'm not here to complain about that. And we're not here to complain, and we're not just here to subscribe any kind of motive to those decisions. But what I do know is this. I know that the South Carolina Attorney General's Office and the United States Attorney's Office share the exact same goals. And the primary goals of those offices are, number one, to protect the public, and number two, to promote respect for the rule of law, and number three, to defer and deter future misconduct, and also, in the end, to ensure that a punishment that is sufficient but not greater than necessary is imposed. And I submit to Your Honor that all of these goals are accomplished in a concurrent sentence. No individual should be forced to serve two separate sentences for the exact same illegal conduct. And I want to address a matter that Mr. Bamberg and Mr. Waters have both raised regarding the Pinckney matter. The Pinckney matter was fully included in the state sentence, and Judge Gergel made that extremely clear. It was included in the loss calculations. They were notified under the Mandatory Victims Act. The loss amounts were included in the loss calculations. The restitution was ordered on the Pinckney case. Ms. Pinckney and Mr. Bamberg were available to speak at the sentencing. They attended all the hearings that I'm aware of, and they've been given treatment just as any other victim in federal court. So that matter has been heard, and it wasn't litigated because Mr. Fleming acknowledged his guilt in those matters. And so this idea that justice hasn't been served in that case, I find, I take issue with that, because it has. I mean, you don't order restitution in a case unless there's findings made and unless they are considered victims in the case, and unless that conduct was folded into the sentence created by Judge Gergel. And so, Your Honor, what I would submit is that the desire to pursue dual prosecutions it's within the discretion of these prosecuting bodies, but it also, that desire still has to be tempered by the rule of law. And justice, I would submit, is not served for South Carolinians or defendants by obtaining multiple convictions in a high-profile case and requiring a man to serve two separate sentences for the same offenses. And that, Your Honor, is consistent with the rule of law. I would submit, Your Honor, that, and there's been a lot of talk about this involves a state license and a state court system and state judges, and I don't disagree with any of that. Of course it does. I mean, that's why we're here, because Mr. Fleming has admitted guilt in that. But when you look to, who the United States Attorney's Office and the Attorney General's Office, who they serve the public. And it's not two separate publics, it is the public. And I don't even say it's to the citizens of South Carolina, because they serve the non-citizens too. They serve everybody. And so I don't understand the division that's being tried to create here with respect to, justice can only be done here in this courtroom. Of course, this courtroom plays an integral role in serving justice. But Your Honor, I believe, understands that the role that these prosecutors have and the role that the other prosecutors have are the same. And they generally work as a team, and they generally work to the same ends, and that is to see justice served. If you look to the American Bar Association's standards on who the client of the prosecutor is, there's a section, and it's in a publication they put out called the Criminal Justice Standards for the Prosecution Function. And it says the client of the prosecutor is the public. And it's not any particular government agency, law enforcement officer, or unit, or witness, or victim. When investigating or prosecuting a criminal matter, the prosecutor does not represent law enforcement personnel who've worked on the matter, and such law enforcement personnel, they're not the prosecutor's clients. The client is the public for both prosecuting entities. So, Your Honor, I would submit that in these proceedings, those purposes are being served. And I don't take any issue with the representation that the Attorney General's office has made, that they have been a central role in this case and that SLED's been a central role. I wouldn't dare to endeavor to do that, Your Honor. Everybody has an important role in this process, and certainly the Attorney General's office and SLED has too. And from my understanding, from all the press releases that have come out from both bodies, they have embraced the idea that this was a joint investigation and there were joint efforts by everybody involved, all the agencies involved, to bring this case to justice. And Your Honor, I would like to take some time to talk about Mr. Fleming and his life before this, his family, his community, many of whom are here today. You've got a packed courtroom. And I would submit, Your Honor, that doesn't happen every day. As Your Honor might be aware, I think that Mr. Fleming is overwhelmed, and he knows how lucky he is and how grateful he is to have the support of so many people. And contrary to what the comment Mr. Waters made, they're not here because they have to be. They're here because they want to be. They're here because, you know, they understand that Mr. Fleming made some terrible decisions. They understand that this has forever changed the course of his life, but they are forgiving and they are supportive. And I think it's a beautiful thing to see, I believe. But Your Honor, I want to take just a brief opportunity to introduce you to Mrs. Fleming. She's here. They've been married for 25 years. She's seated in the courtroom in the front room. His parents are also here. They're Caroline and Frank Koslick and Astor and Catherine Fleming.
Do you want them to stand so I'll know who you're talking about?
Sure. If you all would stand, I would appreciate it.
And who's standing?
So on the far right, we have Eve Fleming. Ms. Fleming's also a member of the bar. She's a public defender here in this area and has worked with juveniles her career. And then we have Mr. Fleming and his wife, Catherine, and then we've got Caroline and Frank Koslick, Mr. Fleming's mom and stepfather. And so, you know, not only have these friends and supporters and this family been here today, they were here, a lot of them came to his guilty plea in Williamsburg County, and a lot of them came to his federal proceedings as well. So it's a very, I can tell you Mr. Fleming is overwhelmed with gratitude for that and doesn't necessarily believe that he's deserving of it, but is extremely grateful. Mr. Fleming also has 2 children. They are not here today. One's in college, and Mr. Fleming felt that it would be better for him to continue his studies and focus on school than he came to the federal plea, and so he's not leaving school to come to this. His daughter just started a job with the Department of Defense.
Do you want them to continue standing?
Oh, no, I'm sorry. I apologize. His daughter's not here today. She's overseas. She's just started a new job, just graduated from college. Mr. Fleming's very proud of her. They all are. She was at his federal plea. And so, you know, I can tell you that the friends and supporters that he have, and we've talked about this in our sentencing memorandum, but I think that it sheds a lot of light on his unique personal history and characteristics, because this is his community and they're here for him. He's had some extraordinary good works, and so I want to take a few moments to talk about that, just to give you some additional insight. And I want to make sure, Your Honor, that I preface these comments by saying nothing that I'm going to say or that his supporters are going to say about him and about why we're here today is meant to diminish his acknowledgement of his guilt or his acknowledgement of the wrongfulness of what he did. Mr. Fleming acknowledges the seriousness of his actions. He feels nothing but remorse, and he has expressed that remorse on multiple occasions, but he specifically did it at the sentencing hearing in federal court, and he's going to do it again today, Your Honor. And I'm sorry that there are some that don't believe it's sincere remorse. I think, Your Honor can be the judge of that. I know that when Judge Gergel listened to his remarks and to the remarks of the people that spoke, he did believe that he was remorseful. It's going to be really hard for me to talk about Corey Fleming's life and do a better job of describing him than the people who have written you letters. And I know Your Honor has received a lot of letters. People are still writing me letters. As of yesterday, I was getting new letters. They keep coming in, Your Honor, and I think that's a testament to how strongly people feel about Mr. Fleming. And a lot of these people have a different story about how Mr. Fleming has made an impact on their lives, how he helped them, how he was there for them when they were in need. They're letters that are written by people from all walks of life. Some live in this Beaufort community, and some are from far away. And some are from our older citizens, and some are from very young adults. And some are from his peer group and his former colleagues. And, these people aren't all people that know each other, but they all have stories about Mr. Fleming. And I would submit to you that there are a couple of common themes that run throughout these letters. The first observation that I had when I read these letters was that, it sort of was in keeping with the theory that I've had since I was a judicial law clerk, and that is that you can tell a lot about someone from how they treat the courthouse staff and the non-lawyers in our system. You've received a lot of letters from some of those people, and they talk about the Corey Fleming that they know, and those people include, a bailiff and somebody who worked in the clerk's office, people who have worked at the solicitor's office with him, a retired state trooper and a court security officer who said that there are not enough accolades in the English language to describe his personality and character. There are several letters from people who worked as his paralegal. There's a letter from an agent with the South Carolina Department of Probation and Parole who's known Mr. Fleming for 30 years. And she describes him as, quote, a wonderful human being. She says his character, his work ethic, and behavior over the course of our personal and professional relationship has been above reproach, and his dedication to serving the community and his clients has been inspiring to witness. And, Your Honor, in addition to the courthouse, the letters that I have received from the court personnel, I've also gotten a chance to personally observe people who have interacted with Mr. Fleming when I have gone to court with him. And this is before he was in custody, obviously, and even, after he's been in custody. But there have been just a number of people who've approached me and who've approached him to just say, that they were praying for him and that they were thinking of him and had nothing but good things to say about Mr. Fleming. And so what this tells me about Mr. Fleming is that, for decades, he has treated all of the people who play a unique and important role in our court system with the utmost respect, kindness, and professionalism. And the second theme that I see emerging from these letters is that, I think you can tell a lot about a lawyer from the way he treats young lawyers. And, there are a lot of letters that Your Honor has received from people who knew Mr. Fleming when they were a young lawyer. I remember being a young lawyer. It's scary. You don't know what you're doing. It's intimidating. But many of these people talk a great deal about how Mr. Fleming would step in and help. When they were first starting, he saw them in court. He understood they didn't know how to do something. He gave them guidance. He gave them advice. He helped them through a hearing. He was never too busy to assist and offer advice. They say when they needed something, they could stop by his office. And, he was never too busy. He would take the time to introduce them to people while he was at the courthouse or at a bar function. He made them feel welcome. They also talk about Mr. Fleming's selfless acts of kindness in helping people who were in the courtroom who didn't have a lawyer because they couldn't afford one, and he helped them anyway. And, Mr. Fleming wasn't writing down these hours to try to get pro bono, lawyer hours or become, known as a pro bono lawyer. He's doing it just simply to help people that needed help. Some of the letters talk about the fact that if the bar had a fundraiser, Mr. Fleming was the first to volunteer his time, to help. The letters describe Mr. Fleming as a lawyer who would stay involved in his clients' lives. He'd help them get jobs. He lent them a car, mentored their children. The list goes on. One letter notes that he's represented the families and the victims of violent crimes free of charge many times during his career, and that he would go above and beyond to help these people through that process for no compensation, only because he knew, and having had a wife who was a public defender, he knew, what that's like, what it means to be in that system. And I do want to quote one letter, Your Honor, from one member of the bar. He said, "I do believe at worst Corey is a good and decent man who succumbed to a very unfortunate lapse of judgment for which he has already paid very dearly." So, Your Honor, I would submit to you that all of the good things that Mr. Fleming did for the legal profession in South Carolina over 29 years, you must also take that into account when fashioning your sentence. And I know that, Your Honor has been sentencing people a long time. I know that it's probably a very difficult part of your job. And I know that you take genuine care in doing this. But when you sentence someone as a whole person. And when you look at Mr. Fleming's life outside of the practice of the law, there's another theme that runs through it, and that is service to his community, service to others. Some of these letters talk about Mr. Fleming and his life as a neighbor, his life as a landlord, someone they knew from the YMCA, who he was very active in getting built in this county, his church. And you look at what they say about Mr. Fleming. They say that he's the guy that comes over at the crack of dawn on Christmas morning when your pipes are broken. He's the guy that helps you move in on the day your moving truck pulls in and then brings you dinner. They talk about the guy that helped with home improvement projects and never asked for anything in return. He's the guy that made sure you had a ride home from the hospital after you had a stroke. These are all from the letters, Your Honor. He's the guy who cried with you when he discovered that your mom had Alzheimer's, and then took the time to take your mom to lunch the next day to make sure he was spending some time with her. There's somebody that some of the letters talk about a man that Mr. Fleming discovered was homeless, and how he helped him find a place to live and has helped him get work. The woman who cleaned his house for years talked about how he treated her like family and invited her and her family to share holidays with them. And so, Your Honor, the stories, they go on and on about the help that in the community that Mr. Fleming has served for so many years. One of the things that stands out to me are the single parents that Mr. Fleming has helped. I mean, they talk about the fact that, he did work around their house. He spent time with their children because they didn't have a father. One woman said, who was an 18-year-old single mother when she met the Flemings, said, "Corey, quote, changed the trajectory of my life, and he changed the trajectory of my 22-year-old daughter's life. He invited her to a play group, befriended her. He drove her daughter to school for 15 years, lent her a car when she needed it, invited them on fun outings, and made them feel like a part of the community." Another person that you're going to hear from today who was not at the federal sentencing but who has come a long way to be here today is Ms. Blue. She was another single mother who rented a house from the Flemings, and she's going to talk about how she was treated by Mr. Fleming in particular. The fact that when she needed help, when she couldn't make ends meet, he was there for her and didn't require her to pay rent. When she talked about when her son got in trouble, he was there for her son. So she's here today, and she's going to address the court. Some of the other letters talk about Mr. Fleming being like a parent to many of his children's friends. There's one couple, and their children's friends were in their early 20s, and I thought this letter was so insightful, written by somebody that young. And she said, "I wish that you know that Corey is so much more than this gross error of judgment. Corey is the type of person who treats strangers like friends and friends like family. I have witnessed countless examples of kindness and generosity towards others, organizations, and their families. So what I would submit to Your Honor, unlike the picture that Mr. Waters has painted for you, that Mr. Fleming was using his, his goodness for evil, what these letters reveal and what these people are going to tell you is that over his lifetime, Mr. Fleming has demonstrated the fundamental values that sustain a community. Another constant thing about Mr. Fleming is him as a father, him as a husband and as a son. And in every single one of the letters, because everybody that knows Mr. Fleming knows that his family is the most important thing in his life, his family and his faith. They all describe him as a devoted family person, loving, caring, present, and someone who sets an example for other peoples in the community about his treatment of his family and his parenting skills. And, Your Honor, this is, I think, as Your Honor knows, all of these cases, and in every case, whether it's white collar or whether it's, any kind of criminal case, it's always hard on the family. And, I think that if there's any solace that Mr. Fleming takes in the decision that he's had to make here, which is to own up to his guilt, it is that he's demonstrating for his children what you do when you make a mistake. You step up, you own it, and you admit you were wrong. And that's what he's done. And that's what he hopes his children gets out of this. Because what he has done is try to do everything human possibly to right the wrong here. You've heard from Mr. Bland that he was the first person to step up and return every bit of the legal fee that his firm took in the Satterfield matter. He's been the first person in this matter to plead guilty, period, and to own up to what he's done.
That his firm took?
I'm sorry, that was issued to his firm. The total fee, $672,000, went to Moskun and Fleming, and then it was split. So yes, that was all returned, Your Honor, in that case. But Mr. Fleming acknowledges his guilt, obviously, in the role he played in getting that fee. But Your Honor, he has stepped up, and this has been obviously a very challenging period in his life. The thing that his friends and his supporters and people know about him, though, is that they believe, and I believe, have faith, that he will learn and he will grow from this experience, and he will come out of this better and stronger. And that's the point of punishment. Part of that is rehabilitation, and I would submit to you, Your Honor, that that's already started occurring. When Mr. Fleming's law license was suspended, he didn't curl up in a ball and lie in bed, okay? He didn't, portray that he was bitter or angry at the world. What he did was started working for Habitat for Humanity. He's very skilled in construction, and he immediately began volunteering his time there because he thought it was the one thing that, he was determined to be productive and determined to be useful in his community and to do something that he could put his skills to work and help other people. And you've got a letter from somebody at Habitat for Humanity who said that Mr. Fleming brought kindness, talent, and humor to the work site. And what I would say about that, Your Honor, is that this speaks volumes about Mr. Fleming, because if you're able to bring kindness and talent and humor to others during the worst period of your life, that's something else. I would just submit to you, Your Honor, that these letters, as a whole, collectively, they're remarkable. And I think, and I told Judge Gergel this, and I'll tell you, Mr. Fleming's never read these letters. And I didn't know these stories about Mr. Fleming until I read the letters, because he'd never told me about some of these relationships or some of the people that he'd helped through these things. But he's never read the letters because, you know, it's very difficult for him to think about the fact of how many people he's disappointed in this case. But what we do know, Your Honor, what I know and what his family and friends know is that at the heart of this, he's a good person who made some very bad decisions. And we know that. We know from our experience that good people do make bad decisions. But I would submit to you, Your Honor, that we are all better than the worst thing that we've ever done. You know, and I want to say for a minute, Mr. Bland mentioned the Georgia bar and the very beginning of this process. And what Your Honor is probably aware of, having been a prosecutor, having been in this system for a long time, Mr. Fleming's not unlike 99.9% of the people that I've seen over 30 years in these situations. And he didn't fully come to terms with what he had done immediately. He admitted to some ethical violations, but he did not admit to his criminal conduct initially. But, you know, he made a decision, and it was a decision made this year, to hold himself fully accountable for his actions. And simply because, not because as Mr. Bamberg put, the feds came and knocking. Mr. Fleming's been aware since the very beginning of this that this was a joint federal and state investigation. So it's always been, the feds have always been involved. There was never any surprise there. But he decided, Your Honor, that he was going to cooperate and he was going to plead guilty. And he wasn't made any promises. He didn't receive any deals. There's no deal. You know, he pled guilty in federal court, and his sentence was calculated by the sentencing guidelines. Like I said, it included both the Satterfield and the Pinckney matters, and Judge Gergel sentenced him pursuant to those guidelines. There was no variance. There was no downward departure. There was no stipulation of a sentence. He took the sentence that was within the guideline range, and he didn't know what that guideline range would be when he pled guilty, and he had no idea what would happen or transpire in state court. But at the end of the day, he made a decision to have faith in this system and to expect, like has been his experience and his wife's experience in the judicial system for a long time, that he would be treated fairly. And that's all he's asked for, Your Honor. That's all he asked for today. I would submit to you that he has accepted responsibility for his conduct. He did not put either the state or the federal government through lengthy litigation or a trial. We didn't come here today to quabble about a trial date. We came here today to fully acknowledge the illegal conduct to which he engaged. I know that I've provided Your Honor with a transcript from his federal plea. I think it's very, very clear in that proceeding, in addition to this proceeding, that he has acknowledged his illegal conduct. And not only that, that he is deeply remorseful for his actions. And he appreciates the fact that his actions have impacted innocent people. And that's the reason he pled guilty. And I will say he is extraordinarily grateful to the Pinckneys and to the Satterfields for their grace. You know, during the federal sentencing hearing, they said they forgave him. They said that again today. That's hugely meaningful to him. And I don't think they'll ever understand how meaningful that is. So we appreciate that, and we appreciate the gracious manner in which they've handled this. So, Your Honor, I would say that Mr. Fleming has suffered, and he has paid a very, very dear price in this proceeding and in the other federal proceeding that would discourage him from ever engaging in similar conduct. And I believe, strongly believe, that Mr. Fleming will serve one day as a very important person who can share his story with other lawyers as a cautionary tale, with just other people. And that in and of itself, Your Honor, will promote deterrence. I believe that the tremendous consequences that he has felt in his professional life, he has voluntarily submitted his resignations to the bar of South Carolina and of Georgia. He will never practice law again. And, you know, that is, it was a profession that, although he made some profound mistakes in, it was a profession for a long time that he loved. And so that itself is a tremendous consequence of his misconduct. Also, Your Honor, I can't not let it be said that the notoriety that has surrounded this case and the publicity that has surrounded it has itself, will serve as a significant general deterrence, but it is not something that every defendant has to deal with. You know, it has been quite, as Your Honor well knows, quite significant. Your Honor, I have some people that would like to address the court, if the court would listen to them, and I would like to call them up now, if that is acceptable to Your Honor. And then Mr. Fleming also has some remarks that he would like to make to the court.
All right, we're going to break for lunch now for 1 hour and 15 minutes. It puts us about, what's that, a quarter to, I guess it'll be a quarter to 3. So we'll be in recess, 1 hour and 15 minutes. unless you want to voluntarily join in.
Your Honor, I do not voluntarily join in anything.
All right, well,
Your Honor, I apologize, Mr. Moore, he just has to say it.
all right, well, I thank you all very much.
Thank you, Your Honor.
Thank you, Judge.
We'll take 2 or 3 minutes and then move back to the Lafitte matter. Veterans Day is on the Friday the 10th, is that it? Well, the deadline will be Thursday the 9th. How about that?
And then responses in 5 days.
And responses in 5 days will